Hey, good morning, everyone. This is Attorney Davis with Davis Legal Center. I wanted to give you this week's Tip Tuesday as if I haven't said enough about it, but it keeps kind of bubbling up, so I felt the need to kind of reiterate this real briefly. So, our office does criminal defense and civil rights cases, okay? But civil rights cases is such a huge umbrella. And there's so many different aspects of civil rights cases. Our office handles like a really slim area within the realm of civil rights. We do inmate and police brutality cases under Section United States Code Section 1983, commonly referred to as 1983 cases. So we only do police brutality and inmate brutality cases. And because we're currently in a health pandemic, I thought it was really important that we kind of talked about, what do you do real quickly if you have a loved one that either you suspect is being brutalized in custody, if they are in a prison or in a jail. And then I think a while back I've already talked about like police brutality cases. So like let's lend a little bit of knowledge and discourse towards inmate brutality cases because it actually does happen more often than you think. So whenever you have a loved one and they are currently in custody, whether it be in jail or whether it be in prison, that could be state or federal prison, there's usually, when they first enter into the facility, they usually receive what we call like an inmate handbook. That handbook is essentially like a Bible, more or less, to the policies and procedures within the facility, whether it's in the jail facility and your loved one is awaiting transport to prison, or whether they're in prison and that is where they'll be at for an extended amount of time. So I always tell those clients to make sure that you get the handbook and you read it because they're giving it to you for a reason. And there are policies and procedures within that handbook that must be followed to a T before an attorney or a lawsuit can even follow. Usually in the inmate handbook, it outlines what we call the grievance policy, and it outlines the policies and procedures that the inmate must follow that is currently in custody, what they must follow and place the institutional notice of before you get a lawsuit or an attorney involved. So I know here in Broward County and also in federal, within the Bureau of Prisons, they usually have like a kiosk or some sort of form that the person can fill out if they are in need of medical care, dental care, if they suspect that a deputy or a corrections officer is abusing them in any way. There should be a policy and procedure in place for that person to be able to write or to place the institution on notice of. That's very important because if you don't, that could come back and hurt you later. Everything must be followed. Everything must be documented to a T. There's a reason why they have those policies and procedures in place. So whatever they are, they're usually listed in an inmate handbook when a person first is processed through a facility. So follow it out and make sure that you hold the institution accountable every bit of the way before you get an attorney involved. Now, when you do get an attorney involved, you want to make sure that you follow the policy and the procedure all the way down to a T. And it's best if it's in writing. I really don't encourage when you're in a situation when it's involving your health or your civil rights being deprived. I don't encourage doing things verbally. So I always tell people, you want to make sure that if there's a written procedure in place that you're following it out to a T. If you're getting medical treatment, or if you've been or if your loved one was brutalized in custody and they are not receiving medical treatment for their injuries, you want to make sure that you document that as well as if the loved one is receiving medical care and treatment in the facility, but they're not getting it timely, or they're not getting the things that they need, or they're not getting all the medication that they need, or whatever the case may be. Again, you want to follow whatever their treatment plan is to a T, and whenever the facility is not doing their end of the bargain, then you want to make sure that you place them on notice before you get an attorney involved. I know I deal with a lot of clients with poor or declining health, and they refuse treatment, and I think it's reckless to do that. I always encourage you, if they are giving you treatment, whatever it is, make sure that you're following it to a T. And if it's not working, like I have a lot of clients who suffer from mental illness, or have pre-existing, very serious pre-existing health conditions, be certain that you let them know, just as if you were out on the if you were out of custody on the outside. If I go to a doctor and I'm on psychotropic medication for my schizophrenia and it's making me feel, off or whatever, I would always bring it to the attention of the physician, the treating physician. So I encourage you to do the same. Okay, so I just realized this video is going way longer than what I had planned on it, so I'll do a part 2. So make sure you stay tuned for this week's Tip Tuesday, all about inmate brutality and how our office can help you. So be sure to get a hold of us if you need us, okay? Bye, everybody. Have a great week.